Today marks the formation of the Supreme Court in the Falkland Islands. Established in 1846, the court deals with everything in the islands from divorces to murder. We spoke to Falklands Radio's in-house legal explainer, Ronnie MacLennan Baird, about what makes the Supreme Court supreme.
It's technically not supreme in the sense there's actually two levels in our five-tier court system above it. So in one sense it sits in the middle of our court system, but in practice it deals with the most important cases. It has the first look at the most important cases, and it also deals with appeals locally. So in practice, if you wanted to appeal a speeding case, for example, you wouldn't end up at the Privy Council in London. If you wanted to appeal it, it would end up at the Supreme Court. If you get charged with a serious criminal offence, you'll end up before the Supreme Court. If you have a civil claim brought against you, or you're making a civil claim and it's above a certain level, I think it's £50,000, then it has to go to the Supreme Court. If it's above £25,000, it can go to the Supreme Court. If you want to get divorced, you have to go to the Supreme Court. The Supreme Court deals with the biggest legal issues locally. As I say, it's not supreme because it's just two levels above it, but that's for appeals on really knotty legal points, and only the knottiest ones would get as far as the Privy Council. The other thing that the Supreme Court does, and it gets the first word, and sometimes actually the last word as well, is a constitutional cases and judicial review. So if a constitutional issue, human rights issue comes up, and actually that nearly came up a few years ago in another case about something relatively straightforward in some ways, but there was someone argued that their human rights were being infringed, and if they pursued that point, that would have had to have been, the case would have had to have been stopped before the senior magistrate and transferred to the Supreme Court for the human rights issue to be determined, and then go back to the senior magistrate to deal with the rest of the case. If you want to challenge something that the government has done to you, you go to the Supreme Court. It's called judicial review, and there's been some recent cases on that: immigration cases, fishing cases, even the rather colourful case a few years ago where with the Canadian lawyers coming down to challenge the Department of Mineral Resources, and that's done in the Supreme Court. The other thing that the Supreme Court has is a specific jurisdiction to deal with membership of the Legislative Assembly. I'm not going to go any further into that for obvious reasons at the moment, but if there is a dispute about membership of the Legislative Assembly and it can't be resolved in any other way, the Constitution says it's dealt with by the Supreme Court, and the Supreme Court gets the last word on that. There's no appeal from the Chief Justice on that one.
So, as you said there, the Supreme Court does a surprisingly busy court for such a small place, but technically, who is it that's presiding over the Supreme Court when it sits in the Falklands?
It's either one of two people. The Supreme Court technically consists of the Chief Justice, and only the Chief Justice. In practice, the senior magistrate is also an acting judge of the Supreme Court, and will deal with, so he would deal probably with some of the things that, some of the claims that have ended up in the Supreme Court for, just because of size, but not necessarily complexity, to avoid delay. He will deal with some of the criminal trials. He will deal with them because there was a recent criminal case. I'm not going to say the name, but there was a recent criminal case. It was in the Supreme Court because of the nature of the case, but it was dealt with by the senior magistrate, but wearing a different wig, so to speak, as acting judge of the Supreme Court, with the powers that gave him. So what will happen is the Chief Justice will come down maybe once a year, maybe a little more often than that, to deal with cases. So that's who the Supreme Court is. It's the senior magistrate and our Chief Justice. The Chief Justice is a senior English lawyer. He has a private practice. He deals with criminal cases. He deals with big commercial cases. He dealt with, for example, he represented the US in the Julian Assange extradition case. He's done the prosecutions on behalf of the Serious Fraud Office. So he's a very, very senior, very well-respected English KC. You've got to remember to call them KCs now. There's not QCs anymore, it's KCs. So he's a very, very senior English lawyer with a private practice who deals with here. Previous Chief Justices have gone on to become senior judges in England and Wales. Simon Bryan became Sir Simon Bryan and a judge of the English High Court.
And with our current Chief Justice being an English judge, presumably a lot of the judges are coming down from England. What is the relationship like between the courts in the Falkland Islands and the courts in England?
We have our own legislation. That's part of self-determination for practical reasons of the quantity of legislation, and also because there's no point in reinventing the wheel. Some UK legislation applies here directly, but some has been adapted for here. Cut and paste with changes. That's slightly belittling the process, a bit more to it than that, but it is UK legislation that's adapted here. We have the law, there's also the common law, case law, which goes beyond just what's actually in legislation, and we have England and Wales common law as here. So in practice, we have English lawyers who come down to deal with to represent the parties in serious criminal trials. We have an English judge who is our Chief Justice, but in practice they are applying the law of the Falklands. But it has a relationship. It has family similarities, and some actually sort of body parts transplanted from the law of England and Wales.
And what role does the Supreme Court play in the modern Falklands? Has there been a recent reform at all? Do you expect a reform in the future?
Well, the Supreme Court itself hasn't been directly reformed. It still has the same sort of structure and the same place in the hierarchy that it used to do. In practice, the criminal procedure has been reformed. I don't know if there's any reforms of civil procedure on the cards, which actually we're still using a mishmash. It's probably an untimed way of putting it, but we're using a hybrid of old pre-1998 UK England and Wales procedure with some modern versions added onto it. That's presumably going to evolve over time. It may need to be looked at again. The big reforms in terms of the criminal procedure, evidence and the crimes, which affect a lot of the business for the Supreme Court, came down were done about 5 years ago and are being kept up to date. They're still in the Gazette and at Legislative Assembly every so often, updatings to criminal procedure and evidence to keep pace with changes and also to keep pace with how things need to work.
Ronnie MacLennan Baird there, giving us the rundown on the Supreme Court.